Hey, ladies and gentlemen, let's roll into our next program, but not too far away. We're going to stick to the alcohol topic. Cheers to compliance, navigating the regulatory landscape of alcoholic beverages and cannabis-infused delights. Joining us today is Miss Emily Harris Gant. She's a principal at the Foster Garvey law firm. She's based in Seattle, Washington, although I want everybody to know that Foster Garvey also has a national practice, as you can see there. She's actually the chair of their national practice for commercial IP and tech transactions practice group at the firm. The other thing Emily does, which is why she's joining us today, is she advises liquor suppliers, wholesalers, and retailers, again, that three-tier spider web, along with cannabis and hemp companies, and how all of that interacts. So we're very fortunate to have her back with us. Emily, take it away.
Well, thank you so much for having me, Stephen, and hat tip to Lauren for a fantastic presentation. Always helpful to have a good basis in the three-tier system before we talk about anything alcohol related. We today are going to do a bit of a kind of a popcorn between different liquor and cannabis focused regulatory issues. As a highlight for today's agenda, we're going to talk about private labels, kind of what you can and what you can't do, traps for the unwary. We're going to talk about hard seltzers and crossover products because they are both very hot and also can be a bit confusing. And finally, we're going to talk about where you can and where you can or should not be serving cannabis and hemp containing products at your licensed premises. Okay, so we're going to roll up sleeves here and talk about private labels. There are a number of you in this space who either may have private labels or are thinking about private labels. It also may be something that the owner of your premises that you are providing these services for may be thinking about. So the classic private label is, say, a Kirkland branded wine, something along those lines. So in this instance, the retailer holds the intellectual property for a brand or for a logo. It doesn't have to be their name. It doesn't have to be, it's not a Costco branded bottle of wine. It's a Kirkland brand, right? And that retailer is going to either purchase the supplier, and by supplier, I mean a winery, a brewery, or a distillery. They're either going to go to that supplier and say, hey, I'd like to buy, 100,000 gallons of your Pinot Grigio, or I'd like to buy X cases of your bourbon with my brand name on it, with my IP. Some states, though not all, will say, hey, supplier, I want you to produce for me a Cabernet Sauvignon at an alcohol by volume percentage between 13.5 and 15 with notes of tobacco, etc. As we'll talk about in a minute, we have to be careful when we look at those types of please make wine to my specifications aspects of things, as some states would consider that the retailer kind of dipping into a supplier's privileges. We are ready for the next slide, please. So here's an example from the hotel space, though it is equally applicable to those of you in the contract F&B space. But here we have Hipster Hotel. They are located in my beautiful city of Seattle, Washington. It's environmentally conscious and it has beehives on its roof. So it knocks on the door of a whiskey producer and says, I'd like you to make a private label whiskey for me, Bee's Knees Honey Whiskey. Hipster Hotel owns the trademark to Bee's Knees Honey Whiskey and then licenses that trademark to the whiskey producer. Under the contract, which similar to Lauren's discussions about things like sponsorship agreements needing to be in writing in most jurisdictions, private label contracts in most jurisdictions also need to be in written format. But under their contract, this Hipster Hotel is the only retailer that can sell bee's knees honey whiskey, but it's okay for the whiskey producer to sell the honey whiskey to somebody else. So they could sell it to, Kroger under a different brand name, let's say. Is this compliant? The answer to that question really depends on the individual state's laws. And so part of the takeaways here are you really got to dig into your state's laws to determine whether or not this type of model is compliant, particularly for those of you that have properties across the nation. That can be a little bit more cumbersome because the laws may differ in different jurisdictions. My beautiful state of Washington. Washington allows private label spirits, assuming that a few conditions are met. The first is that there cannot be exclusivity as to the product. And what they mean by that is not, you're not going to find a Kirkland branded wine at a Kroger, right? That's not the type of exclusivity that they're talking about. They're saying that wine in that bottle needs to be made equally available to any other retailer that wants to buy it, or spirit specifically that wants to buy it. There does need to be a written contract. It needs to be available to Washington's Liquor and Cannabis Board for inspection. And the supplier, here would be a distillery, would submit the COLA to the Liquor and Cannabis Board for review. For those that are unfamiliar with the phrase COLA, it stands for Certificate of Label Approval. That's the kind of blessing on a label that is given by TTB. Although it's not explicit in the Washington state statutes or regulations, the Liquor and Cannabis Board does tend to follow the same basic parameters for wine and malt beverages that it does for spirits. Okay, so what are our teachable moments here? The takeaways for private label products are you really do need to dig into each state's laws to determine whether or not this private label is going to be compliant in this particular jurisdictions. As I flagged earlier, many states, including my beautiful Washington, don't allow that retailer to dictate the specifications of the product. It does need to be a product that is produced pursuant to the supplier's discretion, their decision-making processes, and it needs to be equally available to all retailers. And states are kind of funky about exclusivity. Some states explicitly prohibit exclusivity, like Washington. Other states require exclusivity, particularly as to the label. So as an example, if you're in New York, New York says that Kirkland branded Pinot Grigio can only be sold by Costco, hard stop. Nobody else can sell it. So there's kind of different concepts of exclusivity, which is why it's important to, again, check your state laws and knock on the door of your trusted legal advisor if you have questions on these things. We're going to switch gears, and in our regulatory hopscotch here, we're going to chat about hard seltzers and crossover products. We are going to tackle these together because we see a lot of the questions that come up for these products to be really similar. So we're going to talk about them effectively as a unit. They're both newish, not new, but newish. What we see with a number of our retail clients is that sometimes there's confusion about what the alcohol base for that product is. It's in a can. You assume it's a malt beverage, when in fact, that might be a wine-based product or a spirits-based product. There's also, we're seeing a lot of kind of blurring of lines between the alcohol version and the non-alcohol version of similar products, which is really what we're talking about with these crossover items. And we'll dig into in just a moment. Okay, so here are some of the top selling hard seltzers in the US as of the end of 2022. There's probably nary a person among us that has not had a black cherry White Claw, right? These are very popular products. You will see often they come in a can that's slightly smaller than, say, a can of Diet Coke. or something else, but there's the potential risk for some confusion on these issues. Next slide, please. Okay, so what is a hard seltzer? As Lauren mentioned, TTB is the federal agency that governs suppliers and wholesalers. They don't necessarily license, license retailers, but still a lot of this is driven by TTB because this is how products are made. TTB doesn't technically define what a hard seltzer is. They have provided some informal guidance and noted that a hard seltzer generally is some mixture of a carbonated water, flavoring, and alcohol. Hard seltzers, as mentioned, can be wine or spirits or malt beverage based. And some states have gone through and have started to define things, how they define a particular hard seltzer, but many of them simply follow how TTB treats it. And so if you kind of follow the breadcrumbs on that, if that item has any aspect of a spirits based and was produced by a distillery, TTB is likely to consider that a spirit, and many states will follow that guidance. That's important to check your state's laws, though, in case there are specific definitional aspects of how they consider that product. Next slide, please. We're going to chat about crossover products. So we have Topo Chico, and then we have Topo Chico hard seltzer. No need to pour yourself that Jack and Coke because you can get it in a can. We have Mountain Dew and hard Mountain Dew. And we also have things like Sunny D and this vodka seltzer that we have from Sunny D. So these products are fairly hot right now. And what we're seeing is that because they're relatively new to the market, regulators are struggling a little bit. And they're kind of struggling with what the right answers are. So for things like places like Illinois, they're saying, hey, you need signage up and you need to kind of separate so that someone walking into, say, a grocery store isn't going to walk into that cold aisle and pick up a hard Mountain Dew when they had intended to pick up a Mountain Dew for their 18-year-old. There are some concerns about how some of these products are being merchandised and where that responsibility lies. So if there's, again, using a grocery store example, they are stacking those hard Sunny D's next to the Hot Wheels or things like that, where there are things that are adjacent that are appealing to minors. So states are trying to figure out how do we both allow the industry to innovate and to bring new products to market while at the same time really trying to address the possibility for consumer confusion and to ensure that we're not putting out products that are really are appealing to minors. The last bullet point on here is about slotting fees. As Lauren very accurately stated, there are rules that say, hey, this is what a retailer can accept if there's an exception to the Tied House law, and here's what they cannot. TTB and virtually every state says you cannot pay a slotting fee. And just to make sure we're clear on lingo about slotting fees, if I'm, say, General Mills, I can go to an Albertsons and I can say, hey, I'm going to pay you a fee to put my Cheerios at eye level or to put my cereal on an end cap so that a consumer is more likely to consume it or to buy it, put it in their cart. Same thing with non-alcoholic beverages. So Coke and Pepsi, it's compliant for them to pay a slotting fee. So you could go to a concert venue and say, if you exclusively stock Coke products, we're going to give you special discounts or give you cups or lids or straws or all that good stuff. Those types of activities, with minor exceptions, are generally not allowed in the alcohol space. So for you all, to the extent that you have a retail license, let's say that you are getting Coke and Jack and Coke from the same distributor on that same truck. If Coke is paying you a slotting fee, Jack and Coke could not. And it's really important that you keep great documentation on these issues, because nobody wants to be under investigation from TTB on things like accepting money and including slotting fees, because it can result in some pretty big consequences. All right, so I mentioned that there's a lot of kind of common questions and themes that come up when we're talking about hard seltzers and crossover products. So what is that alcohol base? Is this product spirits, beer or wine based? And the corresponding question here is, do I have the right liquor license to sell this product? If you have a liquor license for, say, a beer wine restaurant license, you can't, in all likelihood, sell a vodka-based seltzer. You need to ensure that you're not acting out of scope by selling this particular hard seltzer. How do I avoid sales to minors? And sometimes it's something as simple as you don't want your staff grabbing a Mountain Dew or a hard Mountain Dew when somebody ordered a Mountain Dew, right? Ensuring that those products are bifurcated, that there's no kind of inadvertent sales to a minor. Am I collecting and remitting the proper taxes? Going back to Washington State, if you have a spirits retail license, then you need to collect certain additional taxes from a consumer, and then you need to remit them to the Department of Revenue. If you think that you're only using beer and wine based products, when in fact you've been selling spirits based products, you may be remitting the wrong and collecting the wrong taxes. So that's an important thing to keep in mind. And then finally, am I receiving slotting fees? Anytime that you are receiving a monetary contribution from anybody that has a liquor license, it's something that your spidey sense needs to tingle, and you really should not do unless you look very, very hard and a skilled lawyer tells you that there is a compliant path. We are going to transition to another of our topics to talk about cannabis and hemp containing products. All right, so how does one tell the difference between a cannabis containing product and a hemp containing product? And really, this is a definitional issue. It is the same plant. It is literally the same plant. And so just like you can breed, say, corn to be yellow corn or white corn or sweeter or starchier, you can breed the cannabis plant to have more THC or less THC, more CBD or less CBD, among other things. So really, when we're looking at the dividing line between what is cannabis being federally illegal and what is hemp meaning federally legal, is the percentage of THC inside of that product. THC is the substance that makes people feel high, stoned. So hemp is 0.3% or less. THC, cannabis is the inverse. If you are north of that 0.3% THC threshold, that is by definition cannabis. More and more states are legalizing either medicinal or adult use cannabis. We are at 40 plus states, Ohio being the most recent. Hemp is something that is federally legal so long as it is grown and otherwise cultivated in conformity both with federal law, and states can still prohibit the sale, production, etc. of hemp. So states like Idaho, it remains a felony to even pass through that state with anything that contains hemp. I think a lot of properties are seeing potential opportunity with cannabis and are seeing means to kind of drive more folks to their premises. It can really be challenging for people that have a liquor license. The vast majority of states say that it can put your liquor license at risk, if you are going to sell, serve, or allow for consumption of cannabis on the premises. And so what we are seeing is a lot of event venues, hotels, restaurants trying to get creative, where they're trying to generate some revenue, particularly if there's, say, a hot dispensary around the corner in a nearby block. So they're trying to find creative ways to thread the needle. And so we're seeing things like, hey, show your ticket stub from our concert venue to the local dispensary and get a 10% discount on your order. Or show your hotel key and get a free product from, the following cannabis retailers. So those are things that, again, all of this is very driven by state law, but most states are saying, hey, ho, you can't do that. They consider it to be some type of a conditional sale, or kind of to this direct or indirect point that Lauren was making earlier in the conversation, indirectly doing what you could not directly do at that premises. So, you really shouldn't take a percentage. Let's say that a cannabis retailer is trying to advertise at your premises. You can't take a percentage of those sales. Arguably, you need to be on their cannabis license. Again, depending on the jurisdiction, but yikes, be careful about those things. Same thing with co-advertising. These are things that are probably impermissible in most jurisdictions. And if there is a path, there is a very narrow one that you really should chat with a skilled cannabis practitioner in your jurisdiction. Okay, hemp, federally legal hemp. Let's chat about that. Non-food and beverage products. We are seeing a lot of properties, often in the hotel space, but they want to do things like have a CBD-based massage, or, have lotions in their spas or things of that nature, because it's a means to drive additional revenue. So that as a threshold question, is hemp legal in that jurisdiction? That's a baseline. Got to start there. Second baseline question is, some states may take the position that because hemp and cannabis are from the same plant, that if you sell, serve, etc., a hemp containing product at your premises, this could imperil your liquor license, which nobody wants to do. What we are finding, or that we're putting in calls to local regulators, chatting with those liquor enforcement officers, getting the green light to say yes, so long as you can document that it is hemp and not cannabis through certifications from the hemp producers and cultivators, and you have appropriate documentation that it is hemp and not cannabis, that they would allow for the sales of those products even at a cannabis or a liquor license premises. I do want to flag that the federal legislation that legalized hemp is the 2018 Farm Bill. The Farm Bill really talks about the production of hemp and the processing of hemp. So growing of hemp and then turning hemp into things like oils, extracts, etc. It doesn't really talk much about the retail sale of hemp. So after the Farm Bill was passed, we saw that a lot of states were not requiring retail sale, like those that were selling hemp at retail, to have a retail type license. That's starting to turn. There are more states that are starting to require those that are selling hemp containing products at retail to get a separate license. So in a lot of states, this is going to be okay for you to sell a non-food and beverage hemp-based product at your premises, but you do need to make sure that you're jumping through the appropriate hoops first. Food and beverage products, relevant to this crowd. So as mentioned, the 2018 Farm Bill is the piece of federal legislation that legalized hemp. The FDA has control over certain items of this, and they came out of the gate and said, look, cannabis and CBD are an element of a FDA approved drug called Epidiolex. Because of that, it is federally illegal to include CBD or THC in foods, regardless of whether that's cannabis-based or hemp-based, if it's introduced into interstate commerce, or if it's marketed as or in a dietary supplement. This is happening all over the place. and people are wildly breaking these laws. I can't advise you to do that, but it is something that is, there's not a ton of enforcement activity on. Where we are seeing enforcement activity are the people that are saying things that are truly egregious. Eat our hemp-based gummies, they will cure cancer. You know, use our, you know, hemp-based lollipop, you'll no longer have Alzheimer's. So those types of things, the FDA is taking more enforcement action on. We've been kind of waiting for the FDA to issue regulations on these issues to provide more clarity on when and if hemp-containing items could be introduced into foods and beverages. And the FDA took a polite pass. So there was a few different citizen petitions to conduct rulemaking to allow marketing of CBD products as dietary supplements. The FDA said, no, thank you. And instead, they really called for congressional action on this. This was in January of 2023. So kind of jury's out on this one. This remains in kind of a holding pattern for now. And really, so is there a safe, compliant way for your properties to sell hemp-containing food and beverage products? There are certain states like California that have issued guidance that says, we're cool on this, guys, so long as, you know, you follow the following guidance. But we need to flag that this still remains federally illegal. So what are those of us on this call? What are the properties need to think about? There are inherent risks, whether you're operating under food and beverage contract agreement, hotel management agreement, etc. Virtually every single one of these says you are representing and warranting that you are going to remain in compliance with applicable law. And that may not be true if you sell food, hemp-containing foods and beverages. So part of this is you need to talk to the owner of the property, whoever the other party to your contract is, to feel them out on that. And if they are going to allow it, you're going to want to document that to kind of protect yourselves. These are things that you should chat with legal counsel about because they do come with some inherent risks. And it's often not a bad idea, though it is facts and circumstances dependent, to talk to your either state, the agency that governs hemp, and also the agency that governs alcohol, to make sure that you're not putting your cannabis or your liquor license at risk. Elizabeth has flagged that it's challenging to get insurance coverage for sales of CBD products and asked if that's something that we have seen. What we see is that it's really challenging to get products liability coverage for anything that is either cannabis or hemp containing. And if anything, what we have seen is that there will be products liability coverage, and then the exceptions in those policies utterly gut the coverage. So this is another, Elizabeth, it's a great point. It's another really practical consideration. You don't want to be selling these things if there isn't basic coverage for it. In the case of something else, sometimes what we'll see is that we will require the contract, not just a purchase order, but the contract between the property and the company that is selling them the hemp containing products to provide indemnity, identify the property as an additional insured on their coverage. But again, their coverage may not be great either. So a great question, Elizabeth. And I think I think I'm all, I think I'm there.
I think that wraps that part up. Hey, that was great. Thank you, Emily, and great question, Elizabeth. It reminds me of that old adage. Hopefully there aren't any insurance folks on the seminar, but when it comes to insurance, the large print giveth and the fine print taketh away. When you were talking about the exceptions kind of gutting the coverages, that's a fascinating question that she asked. And the product's liability coverage is so important today because there's so many things going on. I just made a note that a future topic we all need to think about focusing on, and we can get some insurance experts on here, is to talk generally about insurance available for these types of sales and the products, but also dram shop. As you know, Emily, I know you guys work in that space along with Gray Robinson, but that market is changing as well. So I think stay tuned, folks, because we'll do something on that next year for sure. Let's see. I don't think we have any other questions in chat, but I have a couple of questions for you on the hard seltzers and the visuals you put up. I noticed, and I think you highlighted, there are some interesting claims, vitamin C or antioxidants. So since you mentioned that the regulatory agency at the federal level took a pass, is there any guidance or threshold, not just for the seller, but I'm thinking for the consumer? And I know supplements, so it's just crazy out there. But what's your take on all of that and those promotional additions, I'll call them?
Sure, great question. So there's different agencies that govern alcohol in this way. TTB is a major regulator because they govern the production and sale and the label, but the FDA also has jurisdiction over them. And what we are seeing is a ton of consumer class action litigation over what's on a label. And so sometimes it's that kind of healthy for you, that type of, hey, I thought that this was gonna, make me young and spry again kind of things. And other times it's because, hey, you use the word agave, which implies to me that this is going to be a tequila when in fact it's not. And so there have been a number of class action lawsuits against major suppliers about kind of alleged impropriety or consumer confusion. And a lot of times the defense is, hey, TTB approved this label. And oftentimes those arguments are falling on deaf ears when it comes to the courts.
That's interesting because those cases are probably being brought under deceptive trade.
That's exactly right.
Mm-hmm. Statutes, right? And the penalties under those are quite severe.
Robust.
Very interesting. Yeah, robust. That's the good way to put it. Emily, I just want to make sure for our audience that they also know that you and the Foster Garvey team, which is growing by leaps and bounds, I might add, you are available to preview any of these sales concepts around hard seltzer, around any of the topics, the hemp and et cetera. You guys are available to do that as well, not just after the fact.
We are. That's very true. Thank you.
Okay, just wanted to make sure everybody knew that. Emily, thank you very much. Terrific as always. We hope to see you again soon.
Thank you for having me.
You bet.